Life in a world that keeps changing. Think that it's progress you're making. Copy and paste pretty faces all the time. Pictures so perfect we play.
Hello, everyone. Welcome to Anointed Lady TV, the home of news and politics. If it is your first time in this channel, you are highly welcome. Thank you so much for stopping by. And if you like what we do on this channel, hit on the subscribe button. Also put on the notification bell so you'll be notified by YouTube anytime we drop a new video. And if you are returning subscribers, thank you very much for always coming back to watch our videos. On this platform, we drop videos every day and we react to every video that come our way. And on this very video, I will be watching with you. And after watching, let's go to the comment section and drop our opinion constructively. Like our videos and also share our videos if possible. See you next time.
Trying to approach the courts and rather to be more willing to embrace alternative dispute resolution instruments. This, according to him, will free the courts from unnecessary cases of overstretching both human and material resources in the judiciary. Declaring open the 2023-2024 legal year of the Supreme Court in Abuja, being his last as the Chief Justice of Nigeria, RI0USLY reminded the public that there must always be a winner and a loser after every act of litigation. He emphasized that Nigeria could not import foreign laws to try local cases, as some litigants, in his words, and I quote, would erroneously and desperately want to do in the quest to get victory. Well, Michael Anduaka, the senior advocate of Nigeria, is a former attorney general and a minister of justice. He joins us now to share his thoughts on these comments and others. Thank you for joining us today. Welcome to Newsday again.
Thank you very much.
All right. In your opinion, what manner of alternate dispute resolution instruments do we have at our disposal in order to implement to free the courts of being overburdened and overstretched, especially with these post-election litigations?
Well, it's a lot of dispute mechanism, resolution mechanism. Arbitration is one option that is very popular and is being encouraged now, even up to the Court of Appeal. At the Court of Appeal now, there's an arbitration center where parties may agree or voluntarily go and submit themselves to arbitration, where they iron out their differences and agree on matters, and then the dispute is resolved. And that dispute is resolved especially when the parties submit themselves by consent voluntarily. So that is always very speedily, even in the High Court, arbitration. But arbitration has been an existing part of the Nigerian legal system. Even at the customary court, people will be advised, especially in customary matters. The customary or area courts had provisions where they can refer matters to the traditional to resolve and bring back its finding to the court. And those decisions were always very valid. It was very difficult to obtain them, except you can show evidence that there was a miscarriage of justice, or the arbitrators misconducted themselves. So that is one of the most common dispute resolution mechanisms being employed all over the world now. Of course, the craze for litigation in Nigeria is becoming alarming. Every small thing, people want to go to court. So certain issues, especially commercial dispute, it is better to resolve them because the experts in that area can sit down together, and then the arbitrators who were also experts in that area resolve such dispute amicably. And then those decisions are normally binding, and the courts normally enforce those decisions once you apply to the court, like the Federal High Court, to endorse the arbitral panel's judgment and then decisions, and then it becomes enforceable like a judgment of a court of law. I think that's what the Chief Justice was implying.
Now, while making his opening speech, the CJN said the judiciary as it is today is more deserving of public trust and confidence than ever before, I'm wondering, how do you see this comment, especially when you consider the reactions that have trailed the judgments that the courts have given on election disputes?
Well, election itself is a controversial issue. And normally, judges find themselves at crossroads in matters of election. But that in itself cannot say the Nigerian judiciary is not vibrant. Certainly some decisions were strange. You'd no doubt about it. But if you take the percentage of such decision in relationship to the totality of the decision disposed, there may be less than 5%. So you still call the judiciary an A, but when you put a bagged egg into clean eggs, it contaminates. So one decision which is obviously not in line with the law, if it's given at the tribunal or the court of appeal, people may look at that one decision as if that is the yardstick of the judiciary. But by and large, you have quality judgments that came out of the election matters. But I admit that there are some that certainly the Supreme Court has to look at it to correct them. Because they try to be introducing things that are strange. For instance, there must be a distinction between law or evidence, because the Evidence Act is still a legislation in Nigeria that requires certain things to be done in accordance with the Evidence Act. And then certainly you say, well, if things are done in accordance with the Evidence Act, then you bring Electoral Act and say you are striking all those things because they do not conform with the Electoral Act. There's certainly conflict of laws. So these are matters that the Supreme Court has to look and resolve. Because Evidence Act of 2011 is still an existing law. And then you have an Electoral Act, and then Evidence Act say this is the manner in which you can call a particular witness. Then you use the evidence as to call a witness. Then the judge will say, I'm striking out, it didn't conform with the Electoral Act. There's something missing somewhere, which has to be resolved. These are areas that brought conflict. Of course, some of the judges followed the Evidence Act. Some said, no, let's follow strictly the Electoral Act in calling such witness. Those are areas that also I need, when matters go to Supreme Court, they need clarification so that we can harmonize the existing. Because certain decisions will decide as if the Evidence Act do not exist as a legislation of National Assembly. So these are the areas.
And the last time you were actually on this very program, we talked about the overburdening of the justices, especially at this time. And I think at the time it was 13. It was 13 Supreme Court members justices that we had, and it's down to 10. I want to ask you about the challenges to the process of appointing more justices to fill these roles in an expedited manner, as 10 is the historically the lowest.
I wouldn't want to talk about the challenges, because that has been overcome. The Federal Judicial Service Commission has made recommendations to the NJC. Any minute from now, the NJC will sit, and we had assurance of the Supreme Court on the Supreme Court legal year that the maximum of 21 judges of the Supreme Court will be appointed shortly. So the issue of what has transpired before, that is history. I want us to be positive in mind. There's no challenges much, because the procedure is simple. Federal Judicial Service will receive applications, look at them, shortlist people to qualified people, to judicial officers or legal practitioners, to the NJC, and NJC will make recommendation for appointment to the president. So this is just a procedure we had expected to have been done earlier, but for reason it was not done, but it's now being done. So the issue of challenges is history now. We expect that in the next before the end of this month, Supreme Court will be vibrant with 21 judges handling all matters, and all civil cases, criminal cases that have been pending will be expeditiously disposed of.
Well, now, the CJN also said that the rule of law, with all its well-understood facets, has been highly questionable since the advent of democratic governance in 1999. So I'm wondering what really can be done to ensure that the rule of law flourishes in Nigeria and also that the independence of the judiciary is protected.
Well, you see, starting from 1999, if you see, politics comes with a lot of controversy. Judges have been under heat because of their decisions. You remember the case of Awolowo against Shagari, the issue of two-thirds of the federation came out. It received a lot of negative publicity against the judge, but that was the law in the way the wisdom of the judges saw. Now you have a lot of cases that came to the Court of Appeal. Certainly, some decisions were conflicting. Certainly, some decisions were conflicting, which I think that is some areas that, but there were few negligible that appear to be conflicting with the normal, the flow of decisions coming from the Court of Appeal. And that areas created a lot of heat. But political cases comes with a lot of dust, just like politics all over. It comes with dust because we as politicians were not ready to play according to law. The issue of violence at this 21st century, there's no reason for anybody to be talking of violence. There's no reason that we should be behaving in a barbaric manner. But at the same time, the buck goes to the judges, but the political actors themselves have not shown restraint in order to encourage a peaceful resolution of dispute. Things are overheated, and again, the judges must follow the law to decide one way or the other. But when it comes to who takes the bashing, then the judiciary have no way of defending themselves, leave the politicians and made the case scapegoat. The main people to show restraint is the politicians, the actors in the electoral dispute. We should learn to concede where it is obvious that we need to convince. I did an election petition in Gombe. The person who won got 300 and something thousand votes. The person who lost got 37,000 votes. You won't believe the person who lost went to court. You could see the kind of system we are. Somebody defeated you over 300 votes, 1,000 votes. You got only 37,000 votes, and you still went to court. People still went to court. So we must look at things realistically. Politicians must accept defeat where defeat is clearly established. But of course, where defeat is manipulated, they have a right to seek redress in court of law. And then the court of law also have a duty to protect people where there's apparently inducement and game non-compliance with the electoral law. I think that is where we are talking about.
And still
politicians must show restraint.
Right, and still on the topic of these post-elections litigations, I want to talk about the issue recently in Kano, pretty much a scandal, so to speak. We're wondering, with the CTC and the confusion that happened there, what manner of lack of oversight, or is it incompetence, or is it just an overburdening, as we're discussing here, with the CTC negating its ruling just within paragraphs of each other, and the confusion that was caused, and the alleged clerical error that was made. Can we expect for our judiciary to be error-free?
Where that particular matter is being investigated, I think the Chief Justice said he will investigate. And the people who are culpable will be punished. We await the investigation, but it was not a good situation. I must be frank with you, it was not a good situation. But judges sometimes get a lot of, the society is becoming so difficult for you to, without any clear evidence, to accuse that this judge deliberately did this. You can, who knows? You finish a judgment, you give it out to your secretary, something is smuggled inside. Such possibilities exist. And as a lawyer, which I fear to be a little criminal, I want the investigation to flow before we can conclusively say what happened in Kano is unfortunate against the judges. If it is established the way it is unfortunate. It is not acceptable. It should not have happened. But I am telling you some few areas that we have people, even the Supreme Court, people were punished to have doctored judgments of the court when the judgment finally came out. We have some lawyers who were referred to legal practitioners disciplinary committees. Some have been punished to have incidents of allegations or proven allegations of tampering with judgments of the court. So let the investigation go out. Let's see what is the outcome of it. Then we can talk to Nigerians about this incident. The incident is an isolated incident that has never happened in the history of the judiciary. And therefore, I am so proud of the Chief Justice of Nigeria who said he's going to wade in and investigate to give assurance to Nigerians that there's still hope in the judiciary. I think we will await the outcome of the investigation.
Now, in the meantime, it seems judicial precedents are no longer being respected. You know, in some of the judgments delivered in our appeal courts over election matters, what role can the CJN or possibly the National Judicial Council play in ensuring that judicial precedents set by the Supreme Court are respected at all times?
Well, under the doctrine of stare decisis, lower courts are supposed to follow the judgments of the Supreme Court. For instance, the issue of qualification or disqualification. Supreme Court has clearly in established cases said that it is both a pre-election or post-election. And it's obvious, it's a constitutional issue. If somebody is not qualified, not qualified constitutionally, it can be post-election. It can also be pre-election. Pre-election will be inter-party dispute. The law is settled by the Supreme Court that another party cannot come and step into internal affairs of the party. So it is only those members of the other party who were aspirant that can bring a pre-election complaining that person was not qualified or was disqualified from contesting election. But immediately election ahead, the other party has a window. Because now under the Constitution, he has a right to, and even on the electoral house, he has a right to challenge that person who contested with him is not qualified to have contested. This is the way the Supreme Court resolved it. But I am shocked that people on issues of disqualification, for instance, issue of forge, presenting a forged certificate, which Supreme Court has already dealt with in several cases and settled the law. Still, I saw some judgments from the Court of Appeal or the tribunal came that it was a pre-election matter and ought not to be adjudicated. How can a constitutional matter, a disqualification embodied in the Constitution, how can we sit down and watch an infringement on the Constitution and you say it's a pre-election matter, there will be no remedy? How could the other party, who was not a member of the party, who knew that the person was not qualified, who knew the person had a false certificate, go and join internal affairs of the party or the other party, when Supreme Court has said that he cannot challenge, and a member of another party cannot go and challenge the other party that internal affairs of the party. So this is something that, these are gray areas that we believe we need to go. Supreme Court must be sacrosanct. If decision as law is settled, It goes below. But of course, instances where there may be conflicts in decision, I don't know whether there was another decision of the Supreme Court that the other judges that are saying issue of qualification or disqualification are preeminent matter were following. But if it is established that there was no other authority, then it's questionable. They need to answer why they have not followed the decision of the Supreme Court. They need to answer.
Well, then,
because it's so well established. Can I continue? It's so well established that our Constitution, all parties, including the President, are enjoined to protect the Constitution and to uphold the Constitution. So how can a disqualification embodied in the Constitution, a person will sit and say it cannot be treated because it's a pre-election matter? These are the circumstances that I think we need that are creating a sorry situation that it has to be addressed by the Supreme Court. And judges should be advised strictly to follow the doctrine of stare decisis, precedent, which you said. And doctrine of precedent makes the law predictable and makes parties, lawyers to advise their clients that this is the position of the Supreme Court. So your case, if it goes, you cannot win. But where lawyers cannot predict, where the doctrine of precedent is not followed, lawyers cannot predict. And I can also point to you that this is one of the reasons bringing purification of cases. Because when there's precedent, but still one knows that if I go to court, I can make the decision different from what has been. Except you have convinced the Supreme Court to overrule itself, not really overrule itself, but to depart from its previous decision, where society changes, makes the previous decision impossible to implement. For instance, let me give you an example. First and foremost, there was a constitutional provision that land matters, where the consent of the governor is not first heard and obtained. Transaction, debentures, loan that are given based on collateral without governor consent are void. In Savannah Banks versus Ojolo, that was the position of the law. Banks will give loan, somebody will give collateral with a landed property, go around and make sure the governor does not give the sign, and he will walk away with the money. Supreme Court knew that this was a clear injustice and came to deviate from that position and created a situation. So once there's an agreement, it creates an equitable benefits, obligations for the party to obey. I am also thinking one day an opportunity will come that Supreme Court will look at this issue of 21 days being sacrosanct, in the sense that where a decision is annulled at a superior court and a fresh election ought to be ordered, I believe if de novo, the issues of de novo, I feel that at the time a court orders a matter to be held afresh, time is supposed not to operate because the hardship is enormous. People now wait until somebody goes to court, buy time, and then tribunal objections strike out the matter. The person has a remedy, but time back. Time back should not operate in a manner that will defeat the ends of the Constitution. Rather, it should be interpreted in a manner that will. So, if you look at the Constitution as a whole, there's appellate jurisdiction conferred for the appellate court to review decisions of the lower court. And where they found a decision of a lower court a nullity, and they ought to order fresh hearing of a matter. And if fresh hearing is ordered de novo, times ought not to run. If these issues are put in their prospective position, you will see litigation will go down.
All right. Well, thank you so much for joining us, former Minister of Justice Michael Anduaka. Thank you for joining us.
and gentlemen, good day my brothers and sisters, my mommies and my daddies over there. Is your sister again, your doctor, your friend, your girl, Anointed Lady TV. Please, if today is your first time of coming across my YouTube channel, please do subscribe for me. Subscribe and turn on the notification bell. So each time I upload any video, you will be notified. So in this my channel, I will be bringing up many things to you in which you will benefit from it. I do talk show, I do news, anything you want to talk about, I am into it. Please subscribe and turn on the notification bell. So each time I upload any video or each time I'm on live on YouTube, you will be notified. Thank you very much for always being there for me. Please do subscribe for me, and as you do so, God will richly bless you and meet your heart desire. Thank you very much. I love you all.
Peter Pan, that's what they call me. Promise that you never be lonely. Peter Pan, that's what they call me. Promise that you